The 8A program itself will be fine. Now is it gets you a good time to look into it. It doesn't have to be something so blatant where someone's like, I am firing you because you're black. Bam. Do not be like, well, that means I'm out of luck. They're not really too worried about your past. Even something that can be very serious does not necessarily mean you're completely out of any chance there. Be upfront about it than to try to hide it and hope it never comes up.
We have our special guest back, John Holt, who's actually a real lawyer, to address some topics that many of you have and questions that you have. And, who else can answer these but John? So welcome back to the channel.
Thank you. I'm really glad to be back. It's always fun talking with you, and I'm excited to get started here.
Yes, me too. We're going to jump into it. One of the questions that comes up a lot is people will say that perhaps they are a felon or they have a felony. It could be something they did when they were young. It could be something that happened of recent. And the burning question is, can I still do contracting? They want to know, can they do contracting? Can they get an 8A? Is this really a viable space for them? And I would love to know the answer.
Sure. So first, of course, when it comes to any questions with these, I do have to give the caveat, of course, that anything I say today, is really just general. It's education based. It's if each person's situation is specific. So if you hear this, you think, oh, that means, yep, it's great for me. We recommend, of course, in going into attorney, actually talking about the situation. But this is just to give you a general sense of things for those of you out there who have, maybe a past criminal history or in general, or you're just curious too. So there is no prohibition absolutely on someone having a criminal history and working for the federal government as a contractor. That said, there are considerations you have to take into mind there that does present more challenges naturally than would if you without a conviction. For example, when it comes to just being a contractor in general, the rules are fairly generous with that. They're not really too worried about your past so much as if there's anything currently going on. So if in the past you have some sort of history with, you had a felony back in the day, it is something that, I will say it is something you should definitely be upfront about things if a contracting officer ever asks about stuff. But I looked through the regulations and I did not see anything that specifically stated that there's an automatic sort of, nope, you had a history of your felony, that means you cannot perform. I do want to say though, if you have a history of something where it's something involving fraud or anything like that, that can create challenges that if someone looks into, the government looks into it and they see that, they may want to ask more information or they may want to, find out more information on that. And really in that case, what you really want to do, like I said, is you're going to be upfront. Obviously, of course, if there's something ongoing that you're involved in, always be honest, but definitely get an attorney and, treat that like a criminal investigation, basically, right? But if it's something in your past and basically the matter is settled, and yep, I have this in my history, it's there. Really, the big thing is to just be upfront about it. Because as I looked through it, of course, there's a lot of regulations out there. So I do want to give the caveat again that this is not necessarily absolute for every department or everything, but I'm not aware of anything in general saying that, that, you have this criminal history, you're done. You can never be a federal contractor. So that's the good news there. There are other considerations, though, too, when it comes to, for example, if it's a contract has a security clearance requirement, that might be its own challenge because while you're technically not forbidden from performing on that contract, you would have to get that security clearance. And obviously, in that case, criminal history can be a major issue there. So that is something to be considered. But as a rule, in general, federal government contracts do not forbid even someone with a felony history from performing.
And so I know a proposal I just submitted, they ask if you have, and so then person should be honest and say that they have, and then I guess just be prepared if the contracting officer has follow-up questions.
Right. I will say there is also going to be some, because of the discretion too that, contract officers get when they're evaluating proposals and stuff, and they may, to be frank, they're going to naturally, that's going to be a higher risk, for a performance is it's just a natural thing that someone's going to, kind of assume. And if they do that and they find, that, well, we like to propose stuff, but we think there's this risk here and that blah, blah, blah. For those reasons, we're going with someone else. If you protested that, they're probably going to get a lot of deference on that just because it's a reasonable risk to consider is what GAO or anyone would say. So So again, when I also say, you're not forbidden from bidding or performing, there is a good chance it can be a disadvantage. That's something just to take in consideration. So yeah, just being upfront about it is basically, and being ready is what you have to do. And do not be surprised if it can hurt a bit. But at the same time, I will say, don't be discouraged by that fact. I mean, we've worked with people before who have had, I'm not going to get into specifics about anyone, but we've worked with people who have had, criminal histories of varying natures and stuff, and they still have successful careers in federal government contracting. So I simply mention these things to say, be ready for it and understand it is a disadvantage. But it does not mean that you're completely out of it. Every company faces disadvantages in certain ways or others. So
okay, no, that's good to know. And then does this also apply to somebody who has a felony and wants to get an 8A?
Okay, yes, that's a great thing to segue into that, because it is a bigger deal with 8A, because 8A does have certain character requirements that you're going to have to divulge information on to them, and they may just simply say, we are just concerned about this, and that's we're going to deny, because 124.108 has the good character requirement, and that by its nature, they get it's a broad sort of thing, because they can just say, well, we're concerned about the character issues, and it's really naturally hard to come back against that. So I will say it does create challenges, but at the same time, it is not impossible. There is no absolute requirement that you can never be let in because you have a felony. It is just something that will naturally make it just more difficult. Now, I will say one thing that will basically, be the nail in the coffin for you is you hide it, and you do not share information when they request it. Technically, they could overlook that, but in reality, no. They're going to never overlook that. Anything where you provide false information or try to hide something, I can feel pretty confident saying that's going to be it for you. In terms of your chances of getting into the program. And frankly, even going forward, if you try to apply again, that might come back to haunt you. There's a good chance it comes back to haunt you because, you weren't up front with them. And that's the biggest thing that the government is worried about with its contractors, is basically contractors trying to hide things or, not be up front, because that's where all the corruption and stuff comes from, is from keeping those things in the shadows. So if you have a criminal history, in all cases, and it's asked about either just in general government contracting, or if it's asked about just in, for an 8A application, be upfront about it. I understand that there is a chance it can affect you negatively, but it's way better at that point to be upfront about it than to try to hide it and hope it never comes up, because it will come up eventually. I mean, we are talking about the United States government here. They're pretty good at finding things out. So just be upfront about it, and especially do consider, they will take into consideration certain things. Like if you were really young and you got in trouble, you did something, that can be pretty serious, like a robbery or something, but you were a young kid, and after that you change your life, you can kind of show that, I would imagine, I can't speak for every review or everything, but I would imagine many would take that in consideration. It's like, look, you made it, you did this back then, but never was an issue again, and you've been a law-abiding citizen since then, and you have clearly contribute to society in a positive way. I would like to, again, like I said, can't promise, but I'd like to think that most reviewers would take that in consideration, so even something that can be very serious does not necessarily mean, you're completely out of any chance there.
I think this is really good information. Be honest, be hopeful, be honest.
Yeah.
Are the definite takeaways. And then this is a good segue to talk about the 8A, because there were a lot of trials and tribulations with the 8A program. So I'm curious, where is it right now? Do you think this program is going to go anywhere? And should people still look into applying for the program?
That's a great question. So I will say, I think the 8A program itself will be fine. Whether it stays in this current system where everyone has to basically do the narrative, or goes to the old system of where, the individuals who are part of certain ethnic and racial minorities are getting to get that presumption, that's a bit more unknown. There's no chance, I would imagine, that the fight on that issue is over. But I will say, I think that with the narrative system, I would be surprised if someone challenged that and was successful in that, because with the narrative, basically everyone is getting reviewed there, and each person's considered on their own merits in a sense with that sort of thing. And there isn't this, when we talked the last time, where it was strict scrutiny, where, is the least restrictive the most narrowly tailored means to achieve the goal. I mean, if the goal is to assist people who are in disadvantaged situations from discrimination, which has been held up as an understandable goal and it's a reasonable goal for the government to take, it can't do any less restrict. It can't do something that's even more narrowly tailored than having each person submit a narrative, because you're reviewing each person at their own thing, right? Again, now is that you never know. With the law, things can change in a heartbeat. If one case gets in front of one judge, that can be it for something. But I will say, I think the 8A program as a whole, it will continue. And as such, it will still remain kind of the pride and joy of the SBA. It really is kind of the big program that they do. That's not to, say anything negative about the other programs like SDVSB, WSB, and all that. They're great. But it is where they put most of their effort into maintaining it and everything like that. So I would imagine that if it did come to a fight, SBA would fight very hard to keep it going. I think what this is that they're like, look, with the narrative program, with these narratives, we can still basically achieve the same goals. And so with that said, what we have seen is that, we've when that case came out last July, gosh, it's almost been a year.
Wow.
It's insane. When that case came out, there was a lot of questions on because in the past, what we found was that when people had to do a narrative because they weren't a member of a certain racial or ethnic minority group, and so they'd have to do a narrative to get found to have social disadvantage, SBA demanded basically as many examples as you could give.
Yeah.
Give as much info as you can give. Details. It was a lot of stuff. And so narratives could take a ton of time. Well, naturally, though, when they had to, the court's ruling, they had to switch back to now everyone has to do it. Well, that obviously put a huge burden on them to be able to, to review every single person's. And then also it was a huge burden on people who've already been in the program for ages. So they're like, okay, here's what we're going to do. 2 examples. Give us 2 examples. Who, what, where, when, why, how, basically.
Wow. Just 2?
Just 2. Give us 2 examples of social disadvantage that materially impacted your finances, career, education, something of that nature. That's all, and we'll take a look at it and then we'll make the determination. And I will say too, they have not stated this is an official policy, unlike the kind of the 2 example thing, but I do think they are naturally more lenient than they used to be. And it's such a hard word to say because obviously some of these examples can be very what people go through was very awful, but the impact, I would say, on their finances and stuff is less material. And that's something we have to regularly explain to clients is if we tell you, this example, we don't think it's the best fit for this, we're not saying you weren't discriminated against, get out of here. No. You can be absolute blatant, people calling you slurs, everything bad. But if it didn't impact, your career, you still stay the job. And that's the problem. So we have found that what I would say would be, again, qualifying the word weaker here, just more difficulty meeting that material impact in your career stuff. What would be generally weaker examples, they're kind of a little more favorable to now. And so really, we think in a sense, the 8A program actually kind of is broadened the amount of people who can get in, which is something that, absolutely at the start of this whole, debacle is we were worried it's when they're going to start, really cutting down. I think it's because they're just look, the choice is between either we cut out a lot of people who are deserving or, we keep all those people deserving. Maybe there's a few people that, end of the day, would you say they were that social disadvantaged? That's of course a person's own judgment call, but it's definitely, not ones that, are would say are slam dunks, quote unquote. It's better to keep those in and to make sure that everyone who really has suffered some real material, has hurt their financial ability. They wouldn't even, their company would be in such an amazing, better position. But for all these things, best to keep those people in there, maybe let in a few more than to go the opposite route. So that's what we've seen. So in a sense, there's been a silver lining in all this for those of you who are looking at the 8A program and are thinking, oh shoot, they got to have a narrative requirement. Well, I've got a few things, but I don't think it's enough probably to get in. I think now is a good time to actually look into it and say, hey, this might actually be enough to get me into the program. Whereas, especially like I said, if you're someone who wasn't, you're trying to get in because of you were discriminated because you're a woman, or, you're discriminated for other reasons that aren't specifically related to ethnicity, such as, sexual orientation, things like that. It's actually a bit easier now. And then and of course, then for those who are members of racial and ethnic minority groups who used to have that rebuttable presumption, it has made it, it's a more onerous requirement. Obviously, it was easier to get in when it was presumed. But I will say what we've found is that in our experience, and it's kind of a sad commentary on things, is that many people, I've yet to have one where someone came to us who is a member of a racial or ethnic minority group and is like, hey, help us with the narrative, and them not have any examples to work with, not at least have two. Definitely there's people who have had, worse experiences than others. There's but for what we've seen is, if you look back in your memories, there's probably some time, and again, like I said, it doesn't have to be something so blatant where someone's like, I am firing you because you're black, bam. Obviously, if you have an example like that, we'll use that, obviously. But you'll find that there's a lot of things where, use your reasonable judgment call, because a lot of this stuff always is naturally, people generally don't try to do it blatantly, what we've seen. But there's probably examples in your lives that there's been times that someone has mistreated you and it has had some sort of material impact, even if it's something as small as a small loan or something like that that you look back and it hasn't been the biggest deal, but those things add up. Something denial of a promotion for even a few dollars, that would get you just a few dollars more back in the 90s. You got to consider it. It's not just that promotion, but then you didn't get that, called you back from promotion later on down the road. So that was more money. There's more money there. It snowballs. Right. So definitely, just because you don't have something where it's a blatant, I was fired because of my race or something like that. Do not be well, that means I'm out of luck. Think back in your memories, and there's obviously, of course, I'm not saying, just make something up, but, I think there's a good chance that, unfortunately, historically, that there's probably something in your past where that did occur. So do keep that in mind. And so if you're a bit nervous about the narrative requirement, I would say don't be too nervous about it. It is something more if you're a member of a racial or ethnic minority group looking to get an AA program, but it is not the mountain to climb that it used to be. The mountain's now there for everyone, but it got shortened considerably. So
that's really good to know. And I'm not sure if the SBA does this, but weren't they supposed to make the narratives publicly available?
So that was a concern a lot of people had. The thing about that is, I think it's a rumor that because naturally people were scared about that, because this is stuff that's extremely personal and you're handing it to a government agency, and I'm handing it to a government agency, that means it's going to be made public. There's exceptions to those rules. So we've seen a lot of people come and are asked, well, what about FOIA? Can someone request it under FOIA?
Right.
Now, they could request it, but FOIA has exceptions to it. And one of those exceptions, and forgive me if I'm not quoting it perfectly off the top of my head, but is basically that information that is very personal nature gets exceptions from FOIA. Basically, if someone really wants to get that, they'd have to go fight it out in court. And I'm going to say that most judges are going to be like, you better have a darn good reason for why you need this beyond just trying to, cause trouble, basically. And even then, it would still be such a challenge. So it's something that I absolutely understand why people are concerned. It is something we looked at too, because we wanted to be sure our clients were aware of, the impact. Is there a risk? There's always a risk with everything in the law. There's always, but would I say that the risk is high? Absolutely not. I think it's a very minimal chance that any sort of, FOIA-ish, that these sorts of things would be disclosed to the general public. What I would say is the most, and this is still, I would say, is really unrealistic, but what would most likely happen is if it came to that question. The courts have processes for when we're talking about reviewing sensitive information, because courts understand that there's a balance between the need for the public to have knowledge, which is good. We want to be transparent, But we also want to balance that with the interest of privacy for the people in court, and to make sure that, it's not just simply, all your information's out there. Well, because we got to be transparent, there's a balance. So what courts do, and this, I remember even the term from law school, is it's in-camera review, is that a judge, if it's determined that, hey, we actually do need to take a look at this, see what's up, a judge can order, and we think this would be pretty common in this sort of situation where, all right, I'm going to review. The judge will say, I'm going to review this document, this sensitive stuff. It is absolutely subject to basically a huge protective order that not even the attorneys get to review it. The judge gets to review it, and basically just kind of make the calls off that of whether it matters at all, whether it can be shared, anything. And judges, in our experience, I myself have not seen that, but from what I know from some of my old classmates and things like that, they very much take that very seriously in terms of the in-camera review with protection. So, and that would be I wouldn't even imagine even gets to that point.
Wow. Well, this has been amazing. I mean, I know when I first applied for the 8A, like 2010, 2011, I had to write a narrative, had to, do all of those things. So all of this is it's just so good information to have because there's so many myths out there. And I also want to share with everyone, you all are welcome to connect with John and look into paid services. This is not a sponsored video, but I just want to make it very clear because I personally found when I applied back in 2010, and then I got it in 2011, I paid a company and it made all the difference. I know you can do it for free.
Sure.
I think of all of the things you can pay for. If you want an 8A and you meet the basic requirements, please pay someone. Whoever it is, pay somebody who's really good. And John and them have a great track record. As we kind of come to a close, what are some hot button government things that are going on in addition to 8A and kind of felon bid?
Sure. So what we're seeing is it's a bit quieter right now in terms of just the government's changes and stuff. There are a couple changes, looks like, but that are coming to some of the definitions and things like that for certain FAR regulations. But those are things that happen pretty regularly, about almost like every year. They're going to change a few things. One thing we did see, which was weird, was DOD trying to get back some joint venture facility clearance requirements, which we were actually involved in a case a while back that got rid of those, and they're trying to bring it again. But we've already seen a lot of pushback on it because the agency's argument was basically based on an error. So we've been seeing that. I will say things are a little quieter. So other than that, things are a little quieter right now in terms of changes, like seismic changes. A lot of what we're seeing is just kind of the normal just adjustments, tinkering here and there. But one thing on that, though, is if you do want to keep up to date with those changes, I will, plug our blog here a bit because I use it even as our own resource, too. Sometimes I look back at some things as SmallGovCon, www.smallgovcon.com. That's our blog. My firm does. It's free. You can subscribe. You don't. Just because you subscribe, it doesn't mean we're going to come. Hey, no. This is a free service. Basically gives you updates on things that are changing. Events too, as well. Anything with regards to federal government contracting. We try to keep. Obviously, sometimes there's agencies, they love to get their little memos out just really quietly and trying to keep, but we will find them. And so if you need some information on, hey, especially any big changes, we will absolutely have a post up really quickly after that, just like with the 8A program when that got changed last year with the ultimate decision. So definitely take a look at that. Also, if you are curious about, I will say this, as an attorney, is still not the most exciting thing to read the Federal Register. But if you want to see where the regulations are being changed, and you can even submit comments if you go and check with those things, that they'll propose rules and give you chances to comment, you can do that. So with the Federal Register, the government's, let me get that one sec. I think it's federalregister.gov. Yes, federalregister.gov. We think that's a great resource to be aware of changes. Not just in federal government contracting, but in government regulations in general. So that would be those areas. But yeah, I would say other than that, things are a bit quieter for now. Oh, one thing. We are seeing a general trend for, instead of bid protest, to GAO, because GAO has gotten so deferent to the government in our experience, both us and other firms and us. There has been a trend of people taking protests more to the Court of Federal Claims, which is a more expensive process and a longer process. But the problem is just that GAO has been the deference has been so high that a lot of contractors are a bit concerned. Now, we will say GAO protests are still a great option to consider, but it is something that we, again, do keep in mind. It is a more expensive process, and we don't just suggest it because we're like, I can't. We wanted you to take into consideration, what your experiences are with GAO and things like that. So, but that is something to be aware of too, is you might see a lot more court cases coming out of the Court of Federal Claims lately, just because protests are going there a little bit more, just because people are willing to try their hand with that. So.
No, that's really good to know, because I was very unaware of that. And it's good to know that it's an option and that there's the fees involved, because there have been some that say, well, I want to protest, and that's great, but there are all these domino effects. So I'm glad that you shared that. This has been extremely helpful. Please share the website one more time, John.
Oh, yes. www.smallgovcon, smallgovcon.com. That's our blog there, and we generally try to have about 3 posts a week. Sometimes if it gets super busy, it might be just 2, just because obviously our clients always come first before anything. But we do try to keep that updated very regularly. So
yes, and I love it. I love the site. I suggest you all go. It's free. And if somebody wants to reach out to you, John, should they reach out through the website? What's the best way to connect with you?
So that is one option. Well, our information will be, because it lists us also as authors and stuff for the post. So you'll have our emails there. You can always email me at jholtz, HOLTZ, at Coprince, KOPRINCE.com. If, obviously, if I might not be able to get to you right away, but I will get back to you, or someone at the firm will get back to you. We also have our phone number is our main line. So you'll get in contact with one of our administrative assistants, and they will direct you to one of us. Is 785-200-8919. And so that's another way you get in contact with us. Also, you can just go to coprince.com and make sure, because it's been a while since I've had to look at our own website before. But yeah, that is an option too, is you'll find our information there. Basically just gives emails and everything. So.
No, I love it. I can't thank you enough for being here. I know you'll come back for helping all of us, because there's so much to unravel. And again, I just want to thank you, John. Please reach out to him. Please go to the site. And also, if y'all haven't checked out winnerswaybook.com, winnerswaybook.com, check out the book and subscribe, hit the notification button. And don't forget, everything is possible. Until next time.